Welcome to Legal Environment of Business. This is Professor Monica Spate. We're going to begin with the nature and sources of law, Chapter 1. In this chapter, we're going to discuss the nature of law, give it a definition, identify the sources of law, and then finally, we're going to classify that law. What is the law? How might we define it? Well, we could think of it as a body of principles that governs our conduct, and those principles are enforceable in a court. We could express it as a bundle of rights, or we could think of it as a pattern of rules that society has established to govern conduct. What all three of these definitions have in common is that it's conduct that we as a whole have agreed upon will have consequences. Let's look at the law as an expression of a bundle of rights. A right is the legal capacity to be able to require another person to do something, or the ability to require someone else to not do something, to refrain. With every right, there is a corresponding duty, which imposes an obligation on another person to allow you to exercise your right. So if we want to think about the law as a bundle of rights, it is saying that by looking at our sources of law, we can find where we as individuals have the ability to either do something or cause someone else to refrain from doing something. And in every instance where we are granted a right, there will be a corresponding duty in someone else to allow us to exercise our right or to abstain from interfering with our right. So rights and duties coexist. But one concept I want you to think of is that although we are going to look at sources of law that give us rights, our rights are not unfettered. Our rights are always in tension and will be tempered by the rights of others. Let's imagine that an Aggie student is crossing the street at Sullivan towards the parking lot at Aggie Stadium, and that student is hit by a car that doesn't stop. Then they come to you as their lawyer. What would you do? Intuitively, we all know that it is wrong to hit a pedestrian and keep going. But can we go into court based upon our intuition, upon our general sense of what's right and wrong? No, we can't. You as their lawyer would need to identify a law that either gave the pedestrian the right to be crossing the street or imposed a duty to oncoming traffic to yield to pedestrians. Where would you find those laws? You're going to look in one of the sources of law. So where would we look to find a source of law for our new lawsuit? Well, the first place we might look is the Constitution. We have the U.S. Federal Constitution, and each state has a constitution. The primary purpose of the Constitution is to set up the structure of government. But also included in the Constitution is a Bill of Rights. In our first 11 amendments of the federal Constitution, we have individual rights that have been secured to each person, and that is a source of law. The state constitutions similarly have some delineation of rights that we can use in potential cases. We also have statutes that we can look at. Statutes are the laws created by Congress, our state legislatures, and also our local city, county governments can create laws. Typically, when local governments create laws, they're often called ordinances. Administrative law. The law created by federal or state administrative agencies are usually referred to as regulations. We have federal and state regulations governing many areas of our lives. An example of a federal agency is the Environmental Protection Agency, the EPA. So the EPA is empowered to make laws that regulate how the government, private corporations, and individuals interact with the environment. We also have uniform state laws. While every state has its own body of law, there's some areas where we want to have the law to be consistent across the nation. The Uniform Commercial Code, also known as the UCC, is a prime example of a uniform state law. As businesses operate across this country, they want to have uniform, consistent business laws to operate within. And so the Uniform Commercial Code provides that. Because all of our states have adopted the Uniform Commercial Code, the law relating to business transactions is consistent across the nation. Contract law. This is one of the largest bodies of law. Why? Because each of us can create our own law when we enter into a contract. When individuals or corporations reach an agreement and they put their agreements on paper, or they memorialize it, they create the law that governs their transaction. Your textbook refers to this as private law because it's between private individuals, it's between companies, it's not created by any kind of elected body. Case law. Case law is another source of law, but this law is a little different from the ones we just talked about, which are actively or affirmatively written. Case law is law that's expressed for the first time in a court decision. So I'm going to give you an example, but I'm going to give you an example using a family context. For example, let's say that your mother created a rule that the curfew is going to be 11 p.m. during the week. So that's the rule. The curfew is 11 p.m. during the week. So let's think of that as our law. Alrighty? Now, you have a situation where school is canceled Thursday through Friday. And so Wednesday night, you like to stay out to midnight. And you approach your mother and say, I know it's during the week, but there's no school on Thursday. So can my curfew be later than 11 o'clock? Part of the argument you'd probably be making there is that I believe that the rule that curfew is 11 p.m. during the week is because you anticipate that I would have school or some reason why I needed to be in, but I actually don't have a reason where I need to be in early. So you might want to see if you could appeal this rule and get some different result. So that's sort of parallel to if we have a court case and a party is relying on a statute that says something definitive, like the curfew is 11 p.m. during the week, but then you ask the court to interpret, what does during the week mean? Does it mean just Monday through Friday because that's a weekday? Or does it mean something different? And so you're asking for an interpretation. And so with your mother's curfew, you might get her to think about it and say, well, actually, even though I made the rule and set during the week, I really was thinking about school days. So I'm going to interpret this rule to mean that the curfew is 11 p.m. on a school night. So when the mother, i.e., she's acting as our judge, interprets the general rule, curfew is 11 p.m. on a weeknight, and then she interprets it to mean weeknight really means school night, she has come up with new law. She has kind of created case law because she interpreted a law and said that what that means is something else. Weekday really means school night. So that is our example for case law. Now, if the mother takes that interpretation, 11 p.m. curfew during weeknight means 11 p.m. curfew for school days, and then she applies that case law to subsequent cases. So when your younger siblings ask, does the 11 p.m. curfew still apply when I don't have school? And she says, oh, well, in the earlier case of your older brother, I said school night is when the curfew applies. Then that first case is being used as a precedent in subsequent cases. So even though we have a general rule, curfew for weeknights is 11 p.m., we've got case law that interprets weeknight to mean really school night. And then that interpretation found in the case law is applied as precedent in subsequent cases. So that in future cases, we know that weeknight really means school night. This process of applying case law and precedent to later cases is called stare decisis. Latin term, you read it in the text, but it refers to the process of using case law and precedent and following it in later cases so that we are consistent. Because just like in rules set by parents, we want them to be consistent. If you set a rule for my older brother and I'm the middle child, I'm expecting to get the same rule, and the youngest child is also expecting to get the same rule, because we want to have established precedent so that it helps us to be able to predict and know how we should conduct ourselves in the future. So that's what those concepts of case law, precedent, and stare decisis mean. And just like the earlier forms of law that we can actually go and find in a book, case law, precedent, and stare decisis are sources of law. Common law. Common law is law that has principles that are in the background of our system, of our legal system, that are unwritten, and they are said to come with our settlers from England that they brought with them. Common law really has its grounds in English law. And so the common law is in the background of our American legal system unless it has been changed or repealed by current state statutes. And I'll talk more about common law as we look at specific cases. And then finally, our last source of law are treaties and executive orders. Treaties and executive orders are law that are created coming out of the executive level. The president negotiates treaties with foreign countries, and the president can issue executive orders as a way of creating law without having Congress involved. We've talked about our sources of law. Now we're going to classify that law, put them in buckets depending upon the types. So we have substantive versus procedural, criminal versus civil, and law versus equity. Substantive law versus procedural law. A substantive law creates, defines, and actually tells you what the law is. In contrast, a procedural law tells you the steps that must be taken while trying to enforce your substantive rights. Let's look at some examples. A law that states that a driver must yield to a pedestrian walking in a crosswalk is an example of a substantive law. Why? Because it's creating a right or duty. In this instance, it's giving a driver a duty to yield to pedestrians. So that's a substantive law. Procedural law tells you the steps. For example, a law that states that in order to evict a delinquent renter, the landlord must post a notice 14 days prior to the eviction. This law is giving you a process. If you want to evict someone, you must post notice. It does not determine who would win. It does not hinge on whether or not something, whether or not you actually have paid or not paid. It doesn't determine who's right or wrong. It just sets forth the process that must be followed before you can determine if you win. It's a procedural law. Many times people assume that procedural laws are somehow lesser than or not as important as substantive law. Nothing could be farther from the truth. Substantive law and procedural law are equally important. Procedural law is important in that it specifies steps in a process that must be followed before you can actually enforce what your actual rights are in a substantive law. If you don't follow the procedural law correctly, it may not matter that you had a substantive right to something. Our next category for classifying law is criminal versus civil. Now, this is the category that most of us are very familiar with. Criminal law defines wrongs against society. It's typically found in your state statutes, and the party who is going to prosecute the case, bring the case, is the district attorney, and they're bringing the case on behalf of the state against the defendant. And you're going to see these cases titled as the state of North Carolina, for instance, if we're here, versus the defendant. If the criminal activity took place in Texas, then the title of the case would be State of Texas versus Willard Jones. The prosecutor is bringing the case on behalf of the citizens of the state because the defendant is going to be deemed to be a threat to society. They may have one particular victim, but what they have done could be a threat to all of us. The penalties for such actions are fines and imprisonment. In contrast, in a civil case, we are looking at defining rights and responsibilities among individuals. So these are actions that just interplay between private individuals or corporations. The law underlying these transactions can be found in common law, state statutes, administrative law, contracts especially, and the constitutions. So any of those sources of law we talked about might contain rights and duties that apply in a civil context. In a civil case, the cases are brought by an individual, the plaintiff, against the defendant. And it would be, for instance, Tom Jones versus Willard Smith, or Carla Jackson versus Christy Jones. And the remedy is damages, money. That's what people are looking for in a civil context. They want money. Our final category is law versus equity. This category is more of a categorization of antiquity. In other words, we don't really separate law this way anymore. But in historical times, you would go to separate courts for law to have the courts apply law to the facts, versus if you wanted equity. If you were looking for fairness or for the court to order something other than money, you go to a court of equity. Because in equity, what you're saying when you would go to a court for equity, you would be saying, what money remedies are not adequate in this situation? I need something more in order to prevent unfairness. Examples include if you didn't really have a contract, you don't have all the elements required for a contract, but someone had made you a promise and in reliance upon it, you spent money or time, or you enriched them in some way, and it would be unfair for them to be able to get out of the contract, quasi-contract. Similar situation with promissory estoppel. A really good example would be injunction. An injunction is a request for equity. In an action for an injunction, you're asking the court to stop someone from doing something. One of the cases that you read about was Christian Louboutin versus Yves Saint Laurent, or YSL. Christian Louboutin is known for making really expensive women's shoes with red-bottomed heels. These shoes cost $1,000 or more a pair. And they have a reputation. They have an image. So when people see their red-heeled shoes, they know they're Christian Louboutins. They know you spent a lot of money on the shoes. Well, Yves Saint Laurent started copying this. They decided, hey, we're going to put red heels on our shoes too. Apparently people like them. Maybe they'll buy more of our shoes if we do so. Well, Louboutin had a trademark on the red heels for their shoes, which is a smart thing to do. So they sued Yves Saint Laurent and wanted the court to not only order money damages for violation of the trademark, but they wanted injunctive relief. They wanted the court to issue an injunction ordering Yves Saint Laurent to stop selling red-bottom shoes, because just awarding Louboutin money was not adequate to repair the situation. They needed the competitor to stop violating their trademark and to stop selling shoes with their distinctive red heels. So when a litigant wants an equitable relief, this is when you're asking for something other than money. Now you can ask for this all at one time. You can get legal remedies and equitable remedies, but this is our final way that you could categorize the law.